Good morning to all of you, my dear friends. Today, I welcome to all of you, especially for the Public Information Officer and First Appellate Authority, or those who are complying the request of the citizen or applicant and disposing the appeal of the appellant. Especially, what is the barely necessary for the Public Information Officer and First Appellate Authority? That thing we shall discuss here in this video. So, first of all, I may request all of you, my dear friends, please have look this video and like, share, and subscribe in order to get another new video. My dear friends, as you know that RTI is a fundamental rights. Everybody know it is a constitutional remedy or constitutional amendment or constitutional rights which is given by the government of India. Everybody we know that the simple thing is that RTI is a fundamental right by which any citizen they can lodge RTI application to a public authority in order to access any information, for example, educational development, social development, cultural development, health development, economical development, or in total, we can say that is what is the total well-being of the society that they have to know. And in order to know, they can ask or they can lodge RTI application to a public authority. So this is the rights, RTI, right to information. Then next come, while we are complying the application of an applicant or appeal of an appellant, at that moment we have to follow four principles. Four principles. This is very important for a public information officer and first appellate authority. First one is access to information should be rule and denial to it be the punishment. While citizens they are coming to the public information officer with the fill-upping of a form A and with attachment of relevant documents, that is application fees 10 rupees or ID proof. In these cases, we don't have any right to deny the request of the citizen. So in these cases, what is the available information or disclosable information? We have to provide as soon as per section 7.1 immediately or expeditiously. This is the first principle. Those who are denying or those who are misleading to the citizen, in these cases, there is the provision of a punishment for the public information officer. This is the first and foremost principles of the RTI. Then second, the grounds of a denial to be information to be intimate to the citizen in a such a way so that citizen could know that is why the public information officer is regretted or is not able to provide information. That information we have to intimate to the citizen in a such a way that he could know. Right? For any constraint, any bottlenecks in our public authority, that we have to intimate in a such a way so that he can know. Otherwise, the mention or relevant cause or fact, we have to intimate why we are going to delay this information or what is the time period we need, that everything, what is the constraint, what is the barrier to provide this information, we have to intimate to the applicant is very clear. So this is the second principle of this RTI. Then third principle, very important principle, that is penalty provision for non-compliance of the demand of information or for furnishing of false information by the officials or public information officer. So in these cases, the public information officer, those who have disseminated their proactive disclosure or those who have disclosed their information with consisting of 17 manual in their portal or in their way. So in these cases, updated data should be given. Those who have given non-updated data or incomplete data or misleading data or destructive data, they will be penalized. They will be penalized as per section 20 subsection 2. They will be penalized because it says that is the PIO is misleading to the citizen. PIO is misleading to the public. That's why there is the penalty system for the public information officer. Then fourth one is that is there is in RTI there is the independent grievance redressal mechanism. Everybody know. Everybody we know. In Monday we have the grievance day. But there is no independence. But in RTI, there is the independency. The citizen, he has a right to say the public information officer that I have given the application, but I could not get information within the stipulated time period for 30 days as per section 7.1. I have lost the RTI application as per section 6.1. But unfortunately, I did not get. So that's why PI should be penalized. He can say, or I have to get some compensation because due to late of this information, detrimental I suffered and I lost something else. He can say independently. Who? The applicant. On the other hand, PI also he has a right to say that is, of course, my dears, I have received your RT application, but I prepared information, but I approached to another public information officer as per sections 5(4), referred PIO, but he did not provide me or she did not provide me timely. That's why I could not provide you information within the time period. And everything I have recorded as per Amendment Rule 2006. As per Amendment Rule 2006, Rule 4, I have recorded all these things and I have intimated to the head of the public authority. Due to this cause, I have not given the information to the applicant with a time period or with a timeline. These things I have PIO can intimate to the first appellate authority in the grievance. So it is the independence of the public information officer. And on the other hand, the first appellate authority, he has the right, he is the quasi-judicial authority without any misleading, without any impartial, he can give the decision independently. What he feels right, what he feels correct or legitimate, according to that, he has to give the judgment or decision. So this is the independency in RTA. So this is the 4 principles for the public information officer, first appellate authority. We have to obey it. Then next, this is the flowchart of RTA in Odisha. So there are 4 stakeholders, as we know that. First stakeholder is citizen. In the red icon I have given, the citizen, they have right to access information from our SOMOTO disclosure, proactive disclosure. They can access, they can get it from the, they can download from the website and they can submit the online RT application to the public information officer. And there is the provision, they can check their application status in the site and they can give the feedbacks to the public information officer, whether it is right or not, or whether it is updated or not. So this is the first stakeholder in RTA, that is the citizen. Second is that is we the people, PIO and past appellate authority. We are the second stakeholder. We have to provide information to the citizen. So on daily basis, we have to update what is the need base. We have to update our proactive disclosure. Every interval, time interval or regular interval, we have to update our SOMOTO disclosure. And whatever the information we have online, we have to comply it very soon. And whatever the information we have received, application we have received physically, and we have complied it, we have to enter into the system in order to auto-generate for RT registers. And we have to receive the online RT application and comply it. And we have to maintain all the RT registers, which is auto-generated by this RTA, right? Then in the end of the financial year, we have to, as per section 25, we have to provide data to our parental department or administrative department in order to prepare the annual report data. How much application we have received, how much we have complied. Complied means how much we have supplied, how much we have transferred, how much we have rejected. And appeals also same. So all this data we have to provide our administrative department timely. So this is the second stakeholder. Then third stakeholder, that is the nodal department, information population department. They have right to guide the public information officer of first appellate authority or citizen. They can conduct, they can give any circular, guideline or order or letter or whatever it may be. They can prepare and they can provide the citizen, provide the public information officer, provide the first appellate authority, provide to all the public authority in order to smooth functioning of the game. And another stakeholder is Odisha Information Commission or State Information Commission. Their duties are very important, that they are complying the request of the appeal of the appellant, that is second appeal, and complaint of the appellant, that is under section 18. Those who have complained before the Honorable Odisha Information Commission, they can discuss, they can give decision, or they can dispose of that complaint or dispose of that second appeal. This is the flow chart of RTA in Odisha. What is the responsibility of public authority? The first and foremost responsibility is as a public information officer or first appellate authority in the public authority, we have to comply the mandatory compliance, that is 41 ABCD. 41 ABCD. 41A says that is every record, every RT register. RT register means information register, chaos register, appeal register, annual report, and inspection register. All this register we have to keep in a such a way. We have to catalog, index, file of the file, record of the record, register of the register. We have to keep it for safe maintenance. Then 41B says that is every public information officer, we have to disclose our information, institutional information within 17 manual, with consisting of a 17 manual, both in English and vernacular. We have to disclose our information, institutional information. Then 41C, that is a formulation of policy. Of course, this is made by the department. And 41D, that is quasi-judicial decision. This is also whenever we are giving the decision to the public or to the citizen, at that moment it is affecting to them. Then why it is affected? We have to give the reason under section 41C. The relevant fact we have to reflect it under section 41C. And 41D, that is the quasi-judicial decision. For why this is the things, or this is the matter, it is affected to citizen, and for them this is the rehabilitation program has been taken by the government. All these things we have to intimate, or we have to disclose of 41D. So this is the mandatory compliance for the public information officer. Process of application compliance. This is very important. Please listen carefully. So first of all, whenever we are getting online application or offline application, first of all, we have to make it scrutinized. First of all, application. Whether he has a deposit or not under section 6.1 or rule 4.1, application fees 10 rupees he has given or not, we have to check it. Then as for rule 4.2, we have to check whether he has attached or not ID proof. Because it is written that is after satisfying of the ID proof of a applicant, public information officer may intimate cost of information in order to provide the right. So that's why we have to check the ID proof. Then third one is that we have to observe the subject matter. This application is really relating to us or not. These things we have to observe. If it is relating to us, then we may comply it within the timeline or 30 days. If it is not relating to us and it is relating to another public authority, in these cases, we have to transfer this RTI application within 5 days to another public authority under section 6.3, to whom it relates. This is the process of application. Then how we shall comply? What is the process of appeal? How at that moment, if you are getting online appeal or offline appeal, at that moment we have to see the appellant has attached or not the appeal fees. If it is physically, then he has to give 20 rupees court stamp fee. If it is online, then he has given or not, we have to check it, the e-payment gateway 20 rupees. Right? So this is under rule 7.2. The appellant has duty to attach the appeal fees. Right? Then if it is said that is appeal fees is not attached, then next procedure is how we shall dispose of or reject the appeal. Later on we shall have a point. So in these cases, it has given that is SOP for citizen point number 14, that whenever the citizen they are lodging RTI application appeal to the first appellate authority, the point number 14, it is written that if it is online, then he may do the 20 rupees of e-payment. Or if it is physical, he has to attach the court stamp fee 20 rupees. Right? Then the flow of comply of RTI application. We received RTI application. Then how we shall comply? First of all, we have to prepare the RTI application. What is the question? What is the information we have? We have to prepare first of all. After preparation of information, we have to evaluate the cost. How much? What is the cost of this information? Then after, we have to intimate the cost of information to the applicant as per rule 4.2. Then after depositing by the cost of information by the applicant, then we have to supply as per section 7.1 expeditiously to the applicant. In another case, If it is not relating to us, then we have to reject, we have to transfer to another public authority whom it relates. Then fourth one is that is rejection of application. If it is not applicable, application is not applicable, or he has not given application fees, or he has not given ID proof, or he has not given the cost of information. All these things, there are 9 causes. And for these 9 causes, we may reject RT application from number C, rule 512. So this is the rejection. Then how to comply the or dispose of the appeal of a appellant? First of all, whenever we are receiving the appeal, first of all, we have to give notice to the appellant as per section 19, subsection 9. And the department guideline, comprehensive guideline, information pollution department, the letter number 13806, date 3 December 2011, point number 4, it is written that is, whenever the first appellate authority receiving the appeal, first of all, he or she has to give notice to the appellant in order to attend the hearing, right? So as per section 19(9), he has to give notice to the appellant. Then whenever he is conducting the hearing, after conducting a hearing, or the PI is there, or first appellate authority is there, appellant is there. In these cases, appeal is disposed of. And after dispose of this appeal, as per section 19, subsection 10, the order copy should be intimate to the appellant. Order copy should be intimate to the appellant. And the next, third one is that is, if appeal is not accompanied with the appeal, then we may reject as a first appellate authority as per rule 7, sub rule 4. Thank you so much for watching this video. So in these cases, I may request all of you, please may like, share, and subscribe this video. Thank you so much.